Hello everyone. So my name is Irwin Thomas Wilson, and today I'm going to talk about a important topic in CRPC, uh, and it is a bit of a vast topic. So I'll be talking about it in brief. So the topic that I'm going to talk about is joinder of charges. So before going to it, now let us know what is charge. So charge is defined under section 2B of the CRPC as cha- uh, charge means the head of the charge when there are some more than one charges. So uh, to explain it briefly, put it in layman's terms. So after the trial is initiated, the accused person is informed about the allegations which have been raised against him and the provisions of the code under which he could be tried by the court. So the accusations put up against the accused are thus known as charges in the legal language. So now moving further, we will see what is joinder of charges. So in the case of K. Satwan Singh versus State of Punjab, the section of joinder of charges are not the court held that the section of joinder of charges are not compelling in nature. So they only permit the joint trial of charges under certain circumstances, and the courts may consider the same in the interest of the administration of justice. So, uh, essential provisions relating to framing of charges. So, the general principle regarding charges, as mentioned in section 218 of CRPC, it is said that every offence of which a particular has been accused shall come under a separate charge, and each such charge shall be tried separately and distinctly. This means that each offence has to be treated as a separate entity and should be tried distinctively. But although section 218 clause 1 speaks like this, section 218 clause 2 mentions some uh, exceptions to section 218 clause 1. So that exceptions are section 219, 220, 221 and 223. So speaking of the first exceptions to the section 218 is, so three offences which are of the same kind committed within a year may be charged together. So, according to section 219 clause 1, if a person has been accused of three different offences of three offences of the same kind, so then the person can be tried for all the offences together. So the one condition, the two conditions that 219 mentions is it should be the offences should be of same kind, and it should have been happened in the time span of 1 year. So section 219 clause 2 talks about the offences which are of the same kind also punishable with the same quantum of punishment. So next, moving further, exception 2. So offences which are committed in the course of the same transaction and tried together. So the first one is, if a person has committed a series of acts which are so intrinsically connected together that they form a single transaction, such series of offences shall be charged and tried together. So uh, that is the first one. Second one is, in case of offences of criminal breach of trust or dishonest misappropriation of property, and their companion of offences of falsification of accounts. Many a times the offences of criminal breach of trust or dishonest misappropriation of property are committed along with the offense such as falsification of accounts, etc. So the latter offence committed in order to fulfill the object of the former offence. In such offences, the Section 220 Clause 2 enables the courts to try such offences together. So is next one is if a single act falls under within different and separate definitions of offences, such different offences shall be together tried together as mentioned under section 220 clause 3. So, for example, if X wrongfully strikes a person Y with a cane, then X can either be charged with and tried separately for sections under section 352 and 323 of IPC, or he can be tried together. The charges can be joined. So then next is if the acts which form an offence also constitute different offences when separately taken and tried or taken in groups, such offences shall be tried to be one in a single trial. For example, if A commits the offence of robbery on B, so and while doing so he voluntarily causes hurt to B, then A may be separately charged with and convicted of the offences mentioned under section 323, 392 and 394 of the IPC. So moving to the third exception, that is section 221 provides for the cases wherein there is some doubt related to the circumstances and incidents which took place during the commission of the offense. So, according to this section, section 221 of CRPC, if the accused has committed a series of acts which lead to confusion regarding the facts should be proved. The accused might be charged with any or all of such offences or charged for alternative offences. In such cases, the accused is charged for one offence, and during the stage of evidence, if it is proved that he has committed a different offence, he may be convicted for the same even though it was not mentioned before. So that is what section 221 speaks. So exception 4. Section 223 talks about the class of person who can be tried jointly. This section permits a joint trial of several persons under the specified circumstances. So, as there exists some nexus between various offences committed, the various class shall not be treated as mutually exclusive and could be combined together if necessary. If a group of people try to commit uh, uh, act or a crime, the charges can be combined. That is what section 223 talks about. So now next moving on. So next topic that we will see is power of court to order separate trial in cases wherein the joinder of charges or of offender is permissible. That means even if the joinder of charges principle is applicable, the court in some cases can order separate trial. So the general rule in case of charges is that there shall be a separate charge for every distinct offense. So that is what section 218 mentions. But section 219, 220, 221 and 223 of IPC is the exemptions to this basic rule. So the provisions regarding the exceptions have only enabling nature, and it is at the discretion of the courts whether or not to apply them to a particular case. So, in the famous case of Ranchod Lal versus State of Madhya Pradesh, it was held that it is at the discretion of the court whether to apply Section 219, Section 220, and Section 223 of CRPC or resort to section 218. So the accused has not been given this right to resort to joinder of charges. So the question regarding uh, uh, the misjoinder of charges and joint trial for different distinct offences was answered by the Supreme Court in the case of Union of India versus Ajit Singh 2013. So it was held that the principles underlying the provisions in the Code of Criminal Procedure, that is the exceptions to 218, section 218, is just only a guiding principle. So it is not a mandatory. It joinder of charges is totally dependent on the discretion of the court. So uh, next is a small topic: conviction of an offense not charged when such offense is included in the offense charged. That means section 222 says that if the accused is charged with an offense consisting of several particulars, some of which, if combined and proved to form a minor offense, then he may be convicted of such minor offense. Although the meaning of term minor offense is not mentioned in anywhere in CRPC. So it means an offense which has lesser punishment than the other offense of which the accused has been charged. So this is all about joinder of charges. Uh, Tell me guys how you feel about the topic, and feel free to comment about the topic. Thank you guys.